United States, the great state of Florida, and this honor.
Thank you. Please be seated. Good afternoon. We only have one case on our calendar for today, Bill of Capri Associates v. Florida Housing Finance Corporation. I am certain the clock has been explained to everyone. Counsel for the appellant ready? Let us know if you want any time for rebuttal.
I'd like 2 minutes for rebuttal. May it please the court. My name is Christine Davis-Grave. With me at counsel table is Michael Donaldson, and we represent the appellant, Villa Capri. Every administrative agency is required to consistently follow its own precedent. This court has held several times that inconsistent results of agency action based on similar facts constitute a violation of the Administrative Procedure Act as well as the guarantees of equal protection. Agencies are also required to publish their final orders by subject matter index so that affected persons may locate those precedent, rely on them, and know how the agency has dealt with those decisions in the past.
Counsel, did you raise below the eclipse argument, is what I call it, the fact that the agency would acted differently in eclipse than it was acting in this case?
We didn't because we couldn't, because the Florida Housing had not published the decision on its website contrary to its statutory duty under 12053. We did not find out about the decision until after the final order was rendered in this case. And so that's our primary argument on appeal, is that it wasn't published, and so the material fairness of the proceeding was compromised, as well as the fact that they violated the statute by not publishing it. It caused a material error in procedure.
What is the remedy you seek in this case? You said in your brief that the order of the Florida Housing Finance Corporation should be reversed. Mm-hmm. But what form would that take? Are you asking this court to direct them to loan your client the money, or would it simply just erase everything and start over?
Well, I think this court would have two options. I think that first, since the fact that the original application was correct is undisputed, then this court could reverse and remand back for them to order funding during the next allocation period. The counsel below, in the transcript below, indicated it doesn't matter whether it's located equidistant between Miami and Homestead. The only issue was that there was an inconsistency. So there's no dispute as to that this location has never changed. So we think funding could be awarded on that ground based on the eclipse decision. The second alternative would be just to start over, to send it back to the informal hearing officer and allow her to decide whether eclipse applies, whether the circumstances are identical, whether the original application was correct, and we did not need to cure.
Well, does this, on your first option that you've mentioned, does this court have the authority to require a public corporation like this to loan money to someone? I mean, that strikes me as kind of fairly interventionist. I mean,
right.
What do you think of
that?
I mean,
loaning money may be too strong
of language. If this were SunTrust Bank, let's say, and you went and sought a loan, and they said, no, I'm sorry, we're not going to give it to you, you couldn't come to court and say, make them give me the money.
Right.
Because it would be within their discretion to say, no, this is a different situation. But tell me, how is it so different?
Well, I think, it's sort of a play on words. Saying, okay, court, loan them money, you have to do this is sort of something that you would inherently not think that you're permitted to do and may not be permitted to do. But in this case, we have all the evidence before the court. We have the eclipse decision where the project was funded, and we have the fact that there's no disputed issue of fact as to where the location of this project is, that it never changed.
But in eclipse, the agency said that it agreed with the applicant that the original application correctly identified the address and development location. That's different than there's no dispute about where the property is located. The question is the identification of the location, isn't it?
Well, that's another part of our argument, I think, that we never had the opportunity to show Florida Housing that it was the same. As this went through, you'd have the cure period where we submitted our letter, our FPL letter submitting the cure because they said the address was incorrect. And that resulted in the date having an incorrect date being after the application deadline. In Eclipse, that they did the exact same thing, but when the Eclipse applicant filed his petition for informal hearing, it presented all this new evidence to Florida Housing saying, wait a minute, you can refer to it as either Flagler Avenue or Flagler Drive, and you would still be correct. And so, before the informal hearing started, they were able to determine, okay, well, that's right, so there was no need for a cure. Had Villa Capri known that had happened before, that precedent was out there, it would have submitted different evidence and different argument to Florida Housing in its petition for informal hearing. So it would have, the discussion with Florida Housing would have started off differently as it did in Eclipse. And if we would have gotten to the informal hearing officer part, then the informal hearing officer would have had all of this information before her.
But it's your argument that the evidence, and I think you said undisputed evidence that's in the record, supports the fact that the description, either description that your client has given for this property is correct.
I think it does now, yes. The primary point that Villa Capri argues on appeal, as we've just touched on, is that the precedent has been applied inconsistently. Villa Capri cited two decisions as examples in its brief of where Florida Housing has dealt with similar issues with these electric infrastructure letters and applied them inconsistently. As we just mentioned in Eclipse, it allowed them to show beforehand, after the cure, but before the informal hearing officer hearing, that the address was in fact correct and could be construed as both. Villa Capri never had that opportunity. And in the GHG case, after the Eclipse final order and after Villa Capri final order, the Florida Housing again applied it inconsistently by allowing funding to someone who had an incorrect, inconsistent FPL letter. At that instance, it allowed funding. So there's three examples of where three different circumstances have been applied completely differently. And we argue that not only is this an inconsistent precedent, which this court as well as others have held, is reversible error, and the agency is required to apply consistent precedent, but it's also bad public policy. In this case, Villa Capri submitted a perfectly suitable project. It, at least as far as the preliminary scoring stage, it got the maximum amount of scores available, and it got the maximum amount of tiebreaker points available. So under Florida Housing's arbitrary interpretation of its rule, or arbitrary application of its inconsistency rule or consistency rule, the agency would give subpar projects affordable housing funds and not give those that truly merit funds the funding under the program, because there was a technical inconsistency in the application that was not incorrect. It was just that the applicant had never had the point of entry to tell the agency, wait a minute, Homestead and Miami are both correct. It's just like living in Chairs, Florida. You could put Tallahassee, Florida, or Chairs, and they're both pretty much the same thing. You have the same zip code, you have the same address, and you have the same exact physical location. One point I'd just like to point out the reasoning that was used in Eclipse that I think kind of nails the point home here. In Eclipse, in the joint recommended order that Florida Housing and the applicant submitted, as well as what the order that was actually entered, the order found that there's no need for a cure because both addresses are acceptable and because there was no question that the physical location of the project had remained the same. That is exactly what happened here, and the precedent was not applied consistently. And then the last point we raise in our brief is the failure to publish the decision on their website. Because they failed to publish this decision, that got us here in the first place. We didn't know we could raise this with the IHO. We didn't know before we even got to the IHO we could submit more information that may cause Florida Housing to realize its mistake. And this court and other district courts of appeal have recognized that when you fail to publish an administrative order and allow people interested in the policy to know that precedent affects their case, that's a material error in procedure which requires reversal. And I'll hold the rest of my time for rebuttal.
Good afternoon. May it please the court, I'm Wellington Meffert, General Counsel for Florida Housing Finance Corporation, and with me is Robert Pierce, Assistant General Counsel. We're here for the appellee. First, as to the issue of the physical location of the project, in this case it was never put at issue. You won't see anything in the findings of fact. You won't see any competent substantial evidence in the record. What you see is there was no argument at the hearing about where the location was because it was not at issue. What was at issue was whether the applicant had properly documented, according to Florida Housing's rules, the verification that electric infrastructure was available on or before the application deadline.
Counsel, let me make sure I understand how these rules work. The corporation notifies each applicant of notices of possible scoring errors filed by other applicants.
Yes, sir. Excuse me, Judge, but everything is put on the record. The application, all the supporting material, all the notices filed by others, everybody can look at everybody's application and materials.
But there obviously has a 5-day time period.
It's a very relatively brief time period, yes, sir.
The applicant has to cure the problem. And as I read subsection 9 of the applicable statute, it says two things that seem inconsistent on their face. It says, first of all, that no application shall fail threshold matters as a result of an issue not identified in the notice. And then the next sentence says, however, inconsistencies created by the applicant as a result of information provided pursuant to subsection 6 and 7 will still be justification for rejection of the application or threshold failure, etc., without notice. So on one hand, the section says you can't be denied without having notice, and the second section says, oh, but yes, if you can be denied if it's your second, if the inconsistency or problem is in the cure.
Yes, sir, but neither is final agency action. Neither triggers the point of entry into the proceedings, which is where the informal hearing came in. Once Villa Capri had been noticed of the findings of Florida Housing on the final scores, then that was their opportunity to challenge any decision that was made as to their application, and they did so. Here, the original letter created an inconsistency with the rest of the application. Everything else in the application said the location was in Miami. The scorers looked and saw Homestead and said, okay, this is inconsistent. You need to resolve it. The way they chose to resolve it, rather than taking the opportunity later in the process to challenge that particular finding.
To point out that it really isn't inconsistent because both addresses could be correct.
Well, according to our rule, the USPS address is the one that governs, and in the record there is a reference to that shows that either Homestead, Naranja, Redlands, or one other, but not Miami, are proper, which would have meant everything else in the application was wrong.
So in your view, if you addressed it to this address in Miami, the post office should just say, well, that's not the right address, I'm not going to deliver your mail?
They would deliver it according to the zip code. And,
right.
And that was the issue here, was which city was it in? We're not the postal service.
Since you have a zip code, it strikes me as a remarkably bureaucratic decision to base it on that sort of discrepancy.
That may seem so, and many of the decisions we make, as I noted in the brief, are turn on extremely fine points that outside of this really insular and competitive process would seem hair-splitting or awfully fine. But the rules said that this is the way the rules work, this is the way we're going to play the game, and everybody has to play by the rules. The rules were not challenged in this action.
Would you, and this is hypothetical, that if the applicant had responded to your notice or to the issues by saying, well, this address really does correctly identify the location, and that's what they did in Eclipse, wouldn't you have had a different situation than you had here because they raised a different fact?
We probably would have had an issue of disputed fact that would have gone forward on that basis, and that was where we were headed in Eclipse. When we saw that each unit of local government affected in Fort Lauderdale called this 2-block-long section of street by a different name, either Flagler Drive, Flagler Avenue, or just plain Flagler, at that point we realized we had a factual issue and that we could resolve it without going to formal hearing, or for that matter to go into informal hearing. We agreed that that was the case, that those were the facts, and that Florida Housing original decision was mistaken. Also, the original decision was based on the use of a mapping program that was not adopted by rule for that purpose. So we had made an error of fact and an error of law. And so the way to correct them was to put us back to status quo ante, to say this is correct, this is the correct project address. The rule said you can either provide a street address or an intersection, and in Eclipse they provided an intersection. Now Eclipse was under a completely different program. It was a rental recovery loan program. That was
I certainly recognize
Yes, sir.
that, but it strikes me that you're dealing with sort of the same sort of procedure, it seems to me, in Eclipse as we have here.
process generally, yes, sir. But the same hearing officer who heard Villa Capri, who heard Eclipse, said in a previous case, the Nautilus case that we quote in the brief, that the RLP program is a different program and reliance on its rules as precedent for the universal cycle is misapplied. And I believe that to be correct, that they are different things, that Eclipse is not a precedent, it's not an identical case. It's a different case decided on somewhat different facts and actually at a different point in the procedure. So
What about
I
the
think you distinguish it.
GHG Evergreen case? The appellant cited that in their reply brief, and I don't think you've had really an opportunity to respond to that.
No, sir. And as I can recall, Evergreen was a case that was available at the time, and they didn't argue it in the proceeding below. As I stand here today, I can't remember the facts of Evergreen very well, but I do know that it was a case that we also settled. And I'm sorry, I'm just blanking on the facts of it.
Just wanted to give you the opportunity since it was raised in the reply brief.
Yes, sir. I appreciate that. But in any event,
Is there some guidance within the corporation as to the kinds of errors that are tolerated, that are considered to be inconsequential? I mean, for example, if they had everything right, but they spelled the word Miami wrong, let's say, would you kick the application out for that? Or?
Before I started here, we did, yes, sir, but no more. I mean, we're trying to get away from those sorts of things. And in fact, in the current year's rule, the upcoming year's rule, the zip code issue will go away. But the consistency issue won't. That's something that our scores have nothing else to rely on but what's sitting directly in front of them. They're not the post office. They can't indulge in the conjecture of whether or not the post office would deliver the letter to that particular place. They have to look at the black and white in the four corners of the application in front of them. So the application process itself is sort of like sealed bids. You just have to take what's in the application and look at it and make your best judgment on it and apply those rules. Here, the rules clearly said if it doesn't evidence that it's that location available, infrastructure available in that location before the application deadline, then you must reject it. It says if you file a cure document, it's just like an amended pleading. It completely replaces the earlier document. So the earlier document no longer exists. You have to go on what's on the face of the next document. It said Miami, but it had the wrong date on it. These rules are exacting, and because of the intense competition for this funding, they are very finely parsed sometimes, and the developers know that. This is an experienced developer. It's not a novel situation for them. As we noticed on the issue of the failure to provide notice to them that Eclipse was there, it is true that Eclipse final order was not published in the location that all the other final orders are published for whatever reason. But Ms. Mades, who's the principal for Villa Capri, was the principal there. She filed a NOPSI that started the Eclipse case. That's like filing the complaint in the case. She received actual notice that the Eclipse hearing was going to occur and had the opportunity to intervene in that proceeding and chose not to. And
did she get notice of the final order in there?
No, because she didn't choose to intervene in the proceeding. Had she intervened,
I would have thought it was still going on, right?
Except that in this world, the developers are at every board meeting. They watch every decision we make. We operate in a fishbowl. And it would be hard to believe that an experienced developer would not be aware of a case that they, especially one that they had started.
You said a NOPSI. I thought that's the...
NOPSI and FLOPSI, yes, sir. We have...
I was trying to figure out exactly what you were talking about. Then I looked at the rules.
We have a gazillion acronyms, and sometimes it's easier than speaking English. I see my time is almost out, and Judge, I would urge you, the panel, to affirm the order of Florida Housing Finance Corporation.
Thank you, Counsel.
Okay, I have several points to make that I'll try to go through quickly. Mr. Mefford made the point that the zip code is really the key. Post offices go by zip code. We had the exact same address, the exact same zip code. The location had never changed. Trial counsel below made clear to the informal hearing officer that to them it made no difference whether Miami was correct or Homestead was correct because they admitted that it was in the unincorporated part of Miami-Dade County. The issue was the mere fact that the words were different. So Villa Capri didn't know, as it would have had it had the benefit of Eclipse, that it could show them that, wait a minute, this is a correct address, and we didn't need a cure in the first place. Mr. Mefford brought up the Nautilus case where it made the distinction between the RRLP program and the programs at issue here, but I'd just like to point out there that they were not dealing with the same application or the same parts of the rule. Here, they, as the corporation recognizes in its brief, the application procedure of the RRLP, which was at issue in Eclipse, is patterned after the universal cycle application process here, and as we cited and put in our appendix, the application provisions at issue here are identical. So these cases, I think, are entirely, or Eclipse is entirely precedential because those application provisions are identical. I'd just like to point out in closing that, first of all, you can't imply that a person who is not a lawyer is going to go research everywhere under the sun and find out where a decision is. But finally, if there is a factual issue, as Mr. Mefford implied in his argument just now, then we should be able to go back on the benefit of Eclipse and either have an informal hearing or have a disputed issue of fact hearing at DOA with the benefit of Eclipse and argue, did this location ever change? Did it make a difference? But we shouldn't be kicked out on a technical discrepancy. And I would ask that you reverse and remand.
Thank you, counsel. That completes our calendar for today.